Unit 1. Relevant legislation in the field of real estate. This chapter is intended to inform you about the relevant legislation in the field of real estate in Slovenia. The basic legislation in the field of real estate in Slovenia includes the Substantive Law Code and the other regulations that are complementary to the code, the Land Register Act, the Real Estates Registration Act and the Regulation on the Registry of Non-Proprietary Liens over Seized Property. Property rights are determined by the Substantive Law Code. As a property, it defines a spatially measured part of the Earth's surface, together with all the components. Real estate therefore represents land and things that are permanently and firmly connected to them. The forms of ownership over a property are: property right over a property. Ownership right means that the owner may own, use and consume the thing, real estate, in the most extensive way and to dispose of it, insofar as he is not limited in this right by the rights of others or by law. Possession, economic property and other forms of use of real estate. It is about possessing and using real estate, while the owner is someone else. The person who is registered in the land register is not the same as the one who uses and manages the property. It is a non-proprietary owner, either a tenant, a holder, etc. Lease and rental agreement. With the lease agreement, agricultural land is leased. The time for which the land is leased must correspond to the purpose of the land and lasts from 10 to 25 years. Lease must be differentiated from renting. Building land is rented, not agricultural land. The tenant, renter and lessee have the right to use and enjoy the object of renting or leasing, but they do not have the right to possess it freely, for example, dispose of it. Regardless of the fact of renting or leasing, the owner of the property may sell, transfer, donate or burden with a mortgage, taking into account the information provided by interested parties. Joint ownership and common property. Common property denotes the possession of several persons over a certain undivided property, where their shares are not determined. The joint owners possess the property jointly. Joint ownership denotes the ownership of several persons over an undivided item, for example real estate, where their shares are determined, but if they are not determined, the shares are deemed to be equal. For example, a person is a co-owner of a real estate, if his share is 1/3, because he, together with his siblings and one of his parents, inherited after the other parent. This is usually the result of a legal inheritance. The joint ownership can be broken down so that the thing is sold and the purchase price is distributed among the co-owners. All owners are required to register as owners of the property. Each co-owner has the right to own a property together with others, all of whom can use it, for example, dispose of it, wherein a co-owner needs consent of others to be able to use the property. Each co-owner has the right to propose the division of undivided item by either selling the item and dividing the purchase price among themselves, or if one of the co-owners buys the shares of others at a certain proportional price. Floor ownership. Floor ownership designates the property of an individual part of a building and the joint ownership of common parts, that is, possession over a dwelling and joint ownership over common parts. In the case of floor ownership, no one is entitled to demand the sharing of joint ownership. The next fundamental principle of real estate in the Slovenian legal system is the principle of trust in the land register. The land register is intended for entering and public publication of rights to real estate. All immovable and rights of substantive law that are related to it must be entered in the land register, that is property right over real estate, easement, building right, land debt, etc., as well as obligation for which the entry is prescribed by law. This principle implies the principle of publicity. All data entered in the land registry is deemed to be true, and no one may be harmed by having trusted the information recorded therein. The owner of the property is therefore the one who is entered in the land register as the owner. In the past, the land register was available in physical form, but since 2001 it has been used in electronic form. The land register is run by the court in cadastral municipalities and consists of a general ledger and a collection of documents. The basis for the management of the land register is the cadaster. A cadaster means a record showing the position, the extent and the area of the land. The base unit is a real estate plot. Previously it was a land registry entry. Each property was entered into its own land register entry. Real estate, such as roads, bridges, sidewalks, etc., are called public goods, because they can be used by everyone under the same conditions. The law determines which things are public goods and what are the conditions for their use, but it is possible to acquire a special right to use them, under the conditions laid down by law. However, the state or a local self-government, as the owner of a property, can sell it or rent it. Lease agreements, construction agreements, unless if for this particular form of relationship this is prescribed by the Land Register Act, etc., are not entered in the land register because it is an obligational relationship between the parties. In the event of a dispute concerning such obligations, either the parties agree on their own accord or leave the decision to the court. However, the bona fide buyer receives greater protection. By checking the land register, we can find out who owns the property we are checking. The checking does not require the disclosure of a legal interest, as anyone can check it, and we can check if it is burdened with any other substantive or binding right that is registered into the land register in accordance with the law. Interesting. The land register in Slovenia is in fact the remnant of the land register of a similar record from the times of the Habsburg monarchy. It was started by surveying the land and the population, primarily for tax purposes, that is to say, this development extends from the property books, through the Teresian, Josephinian and Franciscan cadaster, which eventually turned into a land register similar to that we know today. Through the adoption of the Land Register Act, which was revised several times, in line with changes in the regulation, in particular, the transition to common property in Yugoslavia, to the present Land Register Act, and relevant laws concerning denationalization, the continuity of records in land register was preserved. The current owners of a real estate can therefore check the land register and verify who was the previous owner of the property, and who is currently registered as the owner. All denationalization and privatization procedures have not yet been completed, but even if they are, we can still find the country as the stated owner of certain real estate. Checking the land register is recommended, also for anyone who buys a property, to make sure that it is really free of liens and tax. In particular, they require an appropriate price, in the light of such burdens, if they exist. Through the land register, we can follow the changes in certain land, and we can correct the mistakes, and in general, we can also verify who acquired a right over a real estate and who gave it up. In order to avoid any legal proceedings, it is important that an advisor to a foreign investor 1. Knows the relevant national legislation. 2. Prepare and inspect the necessary documentation before advising the investor on investment in the selected real estate. 3. Keep copies of the relevant documentation. 4. Does not recommend investing in real estate, for which all legal documents are not regulated.